So welcome back to Long Crypto. My name is William Krause. I'm an attorney focusing on litigation, governmental investigations, and other disputes related to digital assets and blockchain technology. So it's been about a month since the last episode, and while the markets continue to slow down, there's still been quite a bit taking place with regard to law and regulation around crypto. And truth be told, there's an episode I've been thinking about doing for a couple of weeks and, playing these things out, et cetera, et cetera. I didn't know if I should do it or not. And I decided to do it. So here it is, the long-awaited Kim Kardashian SEC episode. But kind of joking aside, right? Usually I go into these deep dives on macro policy and things like that. But I think one, this is an interesting case. But two, it really does sort of speak to some themes with regard to sort of present day SEC priorities, signaling to the market and people who are sort of involved in it. And then more generally, really their treatment of a lot of digital assets, and sort of viewing them within their jurisdiction as securities. So I think it does make sense for us to work through this, and I'm going to do it now. Feel free to let me know in the comments if you like this, or if there's some content that'd be particularly interesting to you. Don't, however, leave me a comment like somebody did for the last episode, basically asking what the next, 100x altcoin was going to be. Sir, this is a Wendy's. I'm absolutely not going to provide you anything that looks like investment advice on the show. So on that note, you know what's coming, so I'm just going to go ahead and say it. I'm not your lawyer. I'm not your financial advisor. I'm just a humble country solicitor, right, providing macro views on the crypto regulatory landscape and interesting legal disputes. So, nothing I say should be construed as legal advice regarding your specific situation. It might also be attorney advertising, depending on what state you're in. But at the end of the day, these are my personal views for entertainment discussion purposes only. They're not the views of my law firm, and they're definitely not directed to you or your specific situation. So if you want to talk to me about what's going on with your legal problems, feel free to give me a call and we can see about potentially working together. But until that, not your lawyer. You know where to find me. Also, I'm on WKraus, WKRAUSESQ at Twitter. Also my website, which is Butzel. So let's dive in. On October 3rd, the SEC announced this order instituting cease and desist proceedings, market findings, and imposing a cease and desist order against one Kimberly Kardashian, a resident of Hidden Hills, California. So I'm going to find, there we go, what I need to talk about. Bear with me, as always, as I try to set this up for screen share. All right, there we go. Screen share. Cool. So you should now see the SEC order. And, it's staying right there. Right here, Kardashian, age 41, resident of Hidden Hills, California, which is kind of funny. And let me step back for a second. I've seen some news sites trying to make heads or tails of this. At the end of the day, this was not the SEC suing Ms. Kardashian. Instead, this really reflects what happens to the vast majority of SEC investigations. And let me kind of explain, because not a lot of people who are sort of outside that world necessarily understands. So generally what happens, right, when the SEC decides to look into somebody, it's not going to be like a flashy press release as soon as an investigation starts, and there's years of, fact finding, et cetera. It's actually the opposite. In almost every circumstance, it is going to be confidential unless there's some emergency. ICO is about to take place, or some sort of thing that requires an emergency sort of movement or proceeding, a cease and desist. In most other situations, it's really going to be confidential for months, maybe even years, before anybody in the public is informed about it by the SEC. Of course, leaks happen, an insider at the company that's responding might say something, and that happens from time to time, but this is a pretty good indication. So, they basically decide, the SEC goes, they hear about something, they pick it up through market surveillance, and they make a decision to whether or not to investigate. And newsflash, like some haven't said this before, the SEC is on Twitter, they're on Instagram, not just, their SEC site, but they're actually doing the same things to learn about the market that you might imagine, anybody paying attention would do. So, if everybody's talking about, oh, this person did that or that person did this, we saw this with regard to, the Coinbase insider trading thing, right? That started really as a series of tweets, and soon enough, it sort of escalates into governmental, involvement, and that's really how these things go. But, moving forward, say they decide, yes, we think there's an issue here, let's investigate. Sometimes they'll send a voluntary request for information, just a letter, saying we're looking into this for violations of securities laws. we want XYZ documents, or sometimes testimony. But more generally, if the jurisdiction of the SEC is solid, like say a California resident as we have here, they're going to send out a subpoena. And the subpoena is going to go and say, here are the documents we want or the testimony we want. Here's how the document should be sent to us, et cetera, et cetera. Here's a deadline. And that really starts the investigative process. So at that point, if they don't have a securities lawyer already, they go out and hire one and sort of start the process of rolling information to the SEC or getting information to the SEC in response to these requests. And then that process can play out, like I said, for months or years, right? There can be proffers in which the respondent sort of comes in, explains their sort of view of the facts and the law. There can be reverse proffers in which the SEC sort of does the same thing. Any sort of manner of back and forth as there's sort of this fact-finding inquiry or fact-finding process plays out. So again, not a lot of people know that, but at the end of the day, almost always in the vast, vast majority of these investigations, they're going to end with an order that looks like the one we got here with Miss Kim Kardashian. And that's to say, it's going to be sort of a simultaneous order. One, letting the public know that there was investigation in the first place. Two, telling the public what the SEC found. And that's an important distinction because, the media messes this up. Almost always the respondent neither admits nor denies the facts. So, and I think that admit nor deny language is here as well. So it's really the SEC's findings, and then the respondent's kind of standing back and not contesting it. And then it sort of announces the terms of the settlement. So, generally it's agreeing to not do something. That is the cease and desist order. It's basically a legal obligation to stop doing something immediately and not do it again in the future. And then there's also what's called a CMP, which is a civil monetary penalty, which is really just like generally a fine that's paid by the respondent. So here that's $1 million, which is pretty significant chunk of change for reasons I'll explain. And that's it. I mean, at that point, the investigation has sort of both simultaneously opened and closed, if you will, right? I mean, it had been going on for a while, but as far as the public knows, it sort of announced it and then closed it all at once. And unless somebody goes and breaches their settlement agreement, that's really going to be the end of it. For most matters, unless there's something separate that comes up, like say a violation of the cease and desist order. But the fact is, or sort of the takeaway from all that is the SEC very, 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 very rarely goes to court. It's not a dig on the SEC. It's just a function of sort of the way that, these agencies do things. They investigate, they exchange documents, and for both parties' sake, they usually want to come to some sort of a settlement, just like in civil litigation. Like 98% or something extraordinary of all civil claims, I'm talking about SEC, I'm just talking about like fell on a banana peel or something like that. They end in settlement because, parties don't like the uncertainty of going to trial. There's resource considerations. Something like an SEC versus Ripple, which is a full-blown court case in the public, is actually really, really rare. So we talked about, what happens in the vast majority of cases. Let's talk about, Ethereum Max, Kim Kardashian, and the SEC and why we care. So I'd actually mentioned this a few shows back when I talked about Uniswap, and there was a class action that was filed in the Southern District of New York related to Uniswap and its principals, parent company, et cetera. And in short, that lawsuit alleged that, Uniswap, a decentralized exchange, was acting as an unregistered exchange, broker, and dealer under U.S. security law, and essentially engaging in unregistered sale of securities. So, by implication, I talked about this. They had these sort of 6 tokens, and one of them was Ethereum Max. And they said, well, we've got these security violations in so much as these were sold. Well, necessarily, you have to have a finding by a judge or a jury at some point that those were actually securities, right? If they're going to be able to go and piggyback a federal securities law violation on top of that. Now you might remember I kind of bumbled the names a little bit. It was like Boom Bunny and Rocket Bunny or something. I mean, it doesn't really matter, right? But Ethereum Max was one of them. Here the SEC has just come out and said, unequivocally, the SEC has found that Ethereum Max was actually a security, which is why they're able to go and have this sort of security style order here. And, I'll scan down a little bit, based on Ethereum Max's marketing materials, as well as public statements by Ethereum Max, affiliates, websites, social media handles, purchasers would have a reasonable expectation of profits from their investment tokens. And then they actually talk about the second component of the Howey test, which is, based on the effort of others. It's somewhere in here, the magic language, but, the There you go. The efforts of the company. But really what the SEC is doing is they're outlining the Howey test as, sort of modified over time and construed by things like the Dow report and other guidance. And they're saying, listen, we are saying this is security. So, if you've got a class action that's looking to Ethereum Max as one of 6 tokens that might have been a security, and the SEC says it's a security, well, let's just say that's not a great fact for the defense. If you have that kind of lawsuit like Uniswap does. So, and Ethereum Max has also had another lawsuit just off the top of my head. I think it was like Central District of California or something like that. It wasn't really based on the same kind of security findings, more had to do with the promotion side of things, but all the same, it's significant. And actually, if you want to do this analysis yourself with any security, I did a video a while ago, essentially like, is your token a security? And I walked through the analyses and, sort of horizontal, vertical commonality, all the sort of different things that, a lawyer, would generally sort of ask. And again, while you can't, if you're not a lawyer, sort of come to a reasoned, binding legal conclusion, right, that's going to hold up in a court, you get a sense as to what the test really is. And you could have done that analysis that the SEC is doing right here based on, Emacs. So I'm jumping around a little bit, but the important thing is once a token is a security, it really sort of kickstarts a series of other sort of secondary obligations they have to think about. So, if you had someone go on, with regard to a stock, right, like a clear sort of security and say, whatever, I'm the CEO of Ford, Ford's going to go and, do this amazing thing. We're going to, whatever, send a car, a flying car is going to be available, at Ford dealerships, a month from now. And that's obviously a fake example, right? But you make some sort of statement. There's obligations with regard to securities as to what you can say to sort of promote the securities, right? Because then if the value of that stock skyrockets and turns out it was fraudulent, that is a securities law violation, most likely. So this is really what happened here. So in this role, because Ethereum Max has been deemed a security, Kim Kardashian got sort of herself in hot water, unfortunately, because she then became a promoter of a security, an unregistered security at that, which is really anybody who is going and sort of talking about, promoting, sort of pushing investment in a given coin, or sort of at least subtly pushing investment, and more importantly, doing it for compensation. So where is here? Right here, Kardashian received $250,000, approximately $250,000. She was, again, I'm not making a call on law here, but the legal obligations were likely that she was required to disclose that. That, hey, yes, I love Ethereum Max, but also I got paid $250,000 to say that. And, that really sort of goes to the core role of the SEC. Unfortunately, the public can be misled, obviously. And at the end of the day, the SEC is really, really principally focused on investor protection and protection of the markets. So, if somebody's going and getting paid to say something with regard to an investment to sort of lure in people or get them to invest, and then turns out they're compensated, that needs to be transparent, right? A lot of the securities laws just really come back to increasing transparency for investors, required filings, 10Q, stuff like that. It all just really has to do with transparency for the sake of investor protection. And what I'm really saying here is once a token is deemed a security, you sort of become enmeshed in that world immediately with regard to promotion obligations, all this other sort of security law considerations. And that goes a lot deeper than most people, I think understand. So, that's the one significant thing. Also, and relatedly, this is 100% a warning shot to the promoters, celebrity or otherwise, that are attaching their names to these tokens for money. And, we've seen promoters get into trouble many, many times before. But, this is, I think, probably the most famous promoter that I can think of, at least with regard to crypto, that's ever sort of had this issue. And as one sort of former SEC attorney said, I think it was an interview with Coinbase or CoinDesk, sorry, the SEC is always looking for a way to get the message out to the public. And, when somebody with this kind of following that Kim Kardashian has makes a blunder like that, that's a layup for the SEC. And I think that's absolutely right. By entering this order with Kim Kardashian, the SEC got a huge amount of publicity, spread the message far and wide that they're coming after promoters of unregistered securities, which, at least in the eyes of the current SEC leadership, is pretty much every token out there. So that's the thing for everybody to remember. If you're out there pushing, Elon board, Shiba, Rocket, Punk coin, or something like that, and the issuer is quietly paying you to do so, And I can think of a number of sort of well-known personalities that have been alleged to have been doing that in the crypto world. You are rolling the dice. The SEC's not going to turn around and say, boom, that's a security, and boom, you're promoting the security, an unregistered security at that. And then you've got sort of a whole world of federal security law to think about in terms of what you said, when you said it, how you said it, who you said it to, and whether or not you disclose that compensation. And, this is kind of related, not to sort of, lay on the Halloween, scare too heavy here, but, saying it's not investment advice isn't going to save you if you're doing this. So, she says this is not financial advice. And great, that's well and good. I'm sure some lawyer told her to say that, or, Miss Kardashian herself, I understand, has some legal training. Maybe she decided to say that. But, at the end of the day, that is not adequate to satisfy the obligations that sort of came later, which she didn't necessarily know about in so much as this wasn't deemed a security already. But I mean, it definitely looked, smelled, and acted like a security. So, to the extent that she was promoting this, saying this is not financial advice, this is not investment advice, doesn't get you there. Actually what happened was she had to disgorge or get back the $250,000 to pay interest on it and then pay $1 million fine. So then the day failing to disclose this ended up, costing quite a bit of money. So where does this leave the good people of the world who are taking, $1,000 on the side for some NFT project, $25,000 to say, push a crypto at the start of their YouTube show or something like that? Well, if you're in the United States, or, have touch points that would put yourself within the SEC's jurisdiction, you really are playing the odds. The SEC is not going to turn around and say, hey, we saw that YouTube video. We heard you, pushing this NFT project. That was a security. You're a securities promoter. You violated securities law, settle or essentially go to court, which really is what happens. And with today's SEC, you don't want to play those odds. That's not legal advice. Don't be too hypocritical and tell you what's advice or not advice. But listen, generally speaking, nobody wants to violate federal securities law. So I think anybody who's promoting in the crypto space really, really, really needs to be thinking about these things and looking around corners. Because the SEC is very, very actively, more now than ever before, saying that's security, that's security, that's security. They've made it clear they think almost everything is security. They've made it clear what the tests are for deeming it's security. I made a YouTube video about it. If you then go and turn around and say, Elon Rocket Baby Moon Coin, is my best favorite coin in the whole world, and you don't disclose the fact you got paid to say that, that can get you in a tough spot. So, you say this with Kim Kardashian. The SEC is trying to make an example of people, not just for the sake of, being punitive, but Kim Kardashian having this issue gets across this message to a broader audience than I think anything the SEC could have imagined, right? And this is picked up in news outlets all around the world. It's a huge celebrity, social media presence, et cetera, et cetera. I think the message got out there. Now you got to listen, because it's going to be increasingly inexcusable to sort of trip over these landmines in the future. So that's what I got for you. Again, sorry for the Halloween scare, boo, it's SEC. Just kind of kidding, sort of. But hope you enjoyed this episode. For the foreseeable future, I'm going to sort of switch to a once monthly schedule, I think. And then as things kind of continue to sort of get interesting and pick up, or big cases come along, I might sort of deviate from that. But, hope you're all well, and I will talk to you again soon. Thanks.